Well, to get some legal clarity on this particular case, we're now joined by defence attorney Ulrich Roux, who's on the line. Thank you very much for joining us this evening, Ulrich. We're getting conflicting stories coming through. I mean, as lay people, we hear a court order is given out and we should just comply, but it doesn't seem to be that simple.
Hi, good evening, Peter. Yes, there's certainly been some confusion today. But unfortunately, I think in the eyes of many people, General Ntlemeza, technically speaking, and in accordance with Section 18, subsection 4 of the Superior Courts Act, is entitled and was entitled to return to work today. And the reason why is because the Act is very clear that when an execution order is appealed, in other words, the execution order in this instance is the order that we can name the stay-at-home order. So the order that the Helen Suzman Foundation obtained, where the High Court said that General Ntlemeza is not allowed to go back to work pending the outcome of his appeal. Now, in terms of Section 18(4) of the Superior Courts Act, that order is suspended until the appeal is finalized. So, unfortunately, for a lot of General Ntlemeza's detractors, he was entitled to return to work today. What the Act further entails is that an appeal of this nature must be dealt with as quickly as possible. So, indications are that within 2 weeks, we will have an indication of whether this appeal was successful or not. The appeal was only filed and launched on Friday, this past Friday, so that is why it was left, until such a late stage, and I think that is what is contributing towards all the confusion at the moment.
So, in the interim, he's a full employee entitled to carry out his duties as they were immediately before the High Court order?
As bizarre as it seems, that is indeed the case, Peter. And I say that it is bizarre because our High Court has found that General Ntlemeza should never have been appointed as the head of the Hawks. Proper procedure and protocol was not followed. He was not even on the short list of people who were in the running to be appointed as the head of the Hawks, and suddenly he was appointed. He was in the matter where General Sabia's competence to be a policeman was scrutinized 2 years ago in the North Gauteng High Court. The court that found General Ntlemeza to have lied under oath, to be untruthful, and to be a person who lacks the ethical and moral standards which one would expect of the head of the Hawks. So, in light of that, and the courts having found him to be a person of that stature, it certainly is bizarre that they have said that his appointment was not correctly done, but until the appeal is finalized, he is entitled to work.
All right, before we discuss the likelihood of success at a higher court, explain the rationale for this subsection in this law that allows for this kind of situation to arise. There must be some thinking about it.
Yes, well, unfortunately, these anomalies do exist in our law, and some laws are vaguely and badly drafted. If there is a call for the law to be amended, then obviously that should follow the proper procedures and the proper guidelines as to have it amended by Parliament. But at this stage, that is what the law states. It also states that a person, when an execution order, such as the one that has been made, that is not allowed to return to work, is appealed, an automatic right of appeal is granted. So, in other words, the fact that the High Court dismissed General Ntlemeza's rights or his application for leave to appeal is of no consequence because he enjoys an automatic right under this Act. But I think, given his rights and given the fact that he is entitled to return to work, the Act also states very clearly that an appeal of this nature must be heard as quickly and as swiftly as possible, so as to avoid situations like this. But, I did hear some comments today that previous officials who have been in this position, such as Robert McBride, who is now the head of IPIT. You know, one would have expected of a person, if a court has found him not to be competent to be in that position, that he would stay at home, you know, pending the outcome of the appeal. And I do see this, all the shenanigans that occurred today and all the press conferences called and all the sideshows really detracting from the point, and that is that a court has found him to have been appointed incorrectly to the position of the Hawks. That decision is now being appealed, but that person now actually returns to work is once again, it's a bizarre scenario. And
right.
if I were able to advise him, I would have advised him to stay at home, to be honest.
Ulrich, just in closing perhaps, he's going to take this case to the Supreme Court. What is the likelihood that a higher court would look at the facts before the lower court and change the outcome?
Well, the High Court has already indicated that the chances of success on appeal are slim to none. So that is all that we can go on at the moment. It does seem as if his chances of success are very slim. But of course, we'll have to wait for the Supreme Court of Appeal to make that decision.
All right, Ulrich, thank you very much indeed. That's Defence Attorney Ulrich Roux giving us some clarity on a story that's been a bit confusing during the course of the day. But the bottom line, Bening Ntlemeza is allowed to go to work, certainly whilst his appeals being heard in the Supreme Court. Francis?